this lecture, I'm going to talk about legal contracts and how they compare to smart contracts, which we've been talking about for most of this course. Now, I should preface the whole discussion by saying, of course, I'm not a lawyer. My expertise is in computer science. And the legal issues here are extremely difficult. Even credentialed lawyers don't have all the answers. Most of the answers nobody knows yet because there isn't case law. These questions haven't appeared in court. So the goal of this lecture is mostly going to be to give a very basic introduction to contract theory and compare how some of the terms we've been talking about in this class compare to the terms that are traditionally used in contract theory, and to show a couple of the interesting open questions that are raised by smart contracts. So first, let's just look at smart contracts. The term goes back at least to 1994, where it was introduced by Nick Szabo. So I'll let the text on the screen here speak for itself, but just say that the original conception was really just to use computer code to simplify and make more efficient things like arbitrating traditional contracts and enforcing payment and the like. The notion of smart contracts has also been expanded into the notion of smart property. And smart property is really just physical things that can be bought or sold, or generally the control over which can be decided by smart contracts on the blockchain. So a classic example might be a car, could be a piece of smart property. This car will be owned by a smart contract that's on the blockchain. When the car is manufactured, it will be hard-coded perhaps to look for this contract to see who the owner of the car is. Some initial person will buy the car, say Alice, in which case the manufacturer of the car will call that smart contract to note that Alice is the owner of the car. The car will be able to read that from the smart contract and realize that Alice is the new owner, start taking commands like start and stop, open and lock from Alice. And then later on, there might be some mechanism by which this piece of smart property can be exchanged atomically. So Bob might offer some money in exchange for the car, and if Alice accepts Bob's offer, she'll receive the money, but the smart contract will now note that Bob is the owner, and the car will automatically look at that, determine that Bob's its new owner, and perhaps if it's a self-driving car, will even automatically drive over to Bob, but in any case, it will start taking commands to start or lock or unlock from Bob. So really, smart property is just a way for smart contracts to have more effects in the physical world by controlling the ownership or the behavior of some physical objects. So that was the definition of smart contracts and smart property that we've been looking at in the class so far. What does a contract mean in legal terms? Now, like everything else I say in this lecture, this is going to be the common law perception. So every different country has a different legal system. It's impossible to say generalities across all countries and jurisdictions, but we'll talk about the general common law notion of a contract, which is actually pretty simple. A contract is just a legally binding agreement. Or to add a little bit of detail, it's a legally binding agreement between some named parties that specifies rights and duties that those parties have. So that's all it really is, and contracts can take a lot of different forms. You think of a contract as being a piece of paper that people sign, but a lot of other types of agreement are actually enforceable as being legally binding agreements and therefore contracts. So the key ingredient of any contract is that there has to be an offer of terms and an acceptance of those terms. Now, writing is a common way that this is done, although in some cases verbally agreed contracts are also legally binding. But generally, offer and acceptance will have some kind of conversation between the two parties to agree to terms, followed by some ceremony in which they agree to those terms. And typically, this is a physical signature on pen and paper. It can also be a handshake, or it can be an email agreeing to some terms, or a text message. So there's a lot of different versions of acceptance, but the classic version is signatures on a piece of paper. And the legal term that encapsulates this whole process is a meeting of the minds, or sometimes there's this mirror image principle, which means that both parties have to have come together and agreed on the contract. And they should both have the same notion of what the contract is and what it means. Now notice the contract on the previous slide just said what was supposed to happen and didn't say what should happen if the contract went wrong, but it's possible some contracts will specify specific damages or remedies in case one party doesn't live up to duties specified in the contract. So in this example, this contract, in addition to saying that Alice is supposed to reveal this value and Bob is supposed to pay, says that if Alice doesn't reveal, she'll pay a penalty that increases day by day up to some maximum. So that would be a contractually specified damage. Note, you don't have to specify damages. If you don't specify damages in advance at the time that the contract is agreed, then if the contract is breached by either party, you'll have to go before most likely a judge who will decide what an acceptable remedy is for that breach of contract. Now, you don't have to go before a judge. Instead, some contracts will specify some other dispute resolution process, which is usually arbitration, where a third party is named with the power to decide to make a binding decision on remedies in case there's a breach of contract. So in this example, Alice and Bob have both agreed that if there's a breach of this contract, Carol will make a decision about how much money Alice is supposed to pay as a remedy. And it's also possible for contracts to be unilateral, which changes a few things. There isn't really a meeting of the mind in this case, but it's possible for one person to make a binding commitment to take some action if anybody else does this. The classic example is putting up a poster offering a reward for a lost pet, but you can think of a lot of examples in the blockchain case where one person publishes a smart contract that promises most likely to give some reward to anybody that is able to specify to provide some value to that contract. So that can still be a legally binding agreement. There's no requirement that more than one person agrees to it. So to summarize, let's look at some of the components of contracts and all the different ways they can be realized and compare to smart contracts. So contracts are usually specified in natural language. Sometimes it's a little modified to be legalese, or how lawyers like to use natural language. And assent, like I mentioned, can be often physical signatures, pen and paper. It can be a handshake. There's various forms. Dispute resolution is handled either by judges, the formal legal court system, or it could be by some specified third-party arbitrator. Judges do have the power to nullify a contract after the fact for a number of reasons, which we'll get into shortly. And if any payment is required, generally contracts actually don't specify mechanisms of payment, but they might. And if money needs to be held in escrow, then some specific third party will need to take care of that. Smart contracts, on the other hand, they're specified in code, specifically in EVM code. It might be compiled from another language like Solidity, but what actually gets published on the blockchain, which is the binding agreement, is the EVM code. Assent, or agreeing to a smart contract, is done by a digital signature. So to the extent that public keys represent persons who are capable, who have the capacity of agreeing to a contract, issuing a digital signature on some message to that contract is in some ways an assent, is interpreted as an assent to that contract. Dispute resolution isn't really specified. The philosophy is basically that whatever the Ethereum virtual machine says is the interpretation of that code is the result of the smart contract. And nullification isn't really specified either. We've seen at least one example, arguably, of nullification through the response to the bug in the DAO. But generally, to nullify a smart contract requires some sort of fork in the consensus process to either change the rules to interpret that contract differently or remove it from the blockchain altogether. One of the real benefits smart contracts have over traditional contracts is that payment is, of course, built in, and escrow is also built in. Although this is also a downside if you think about it. Traditional contracts have the ability to just say, Alice shall pay Bob if something does or doesn't happen. Whereas for any kind of payment in a smart contract, you have to basically put all the money up front into escrow. Traditional contracts don't have that problem. They can simply require that payment happens at a certain point in the future. So there's a couple of different ways that we can look at smart contracts. The simplest is to just say smart contracts are really just a subclass, a special type of traditional contract where the offer and acceptance is digital, the performance, the remedies are digital, but otherwise they hold water as a traditional legal contract. So this view was, somewhat endorsed by a U.S. congressional report about smart contracts. Of course, that's not legally binding. It's not a ruling from a court, but there's some support for this viewpoint that smart contracts are really just, a new way to agree to a contract, but fundamentally all of the basic tenets of contract law still hold. There's another way to view smart contracts in the traditional legal framework, which is that they're a form of what's called self-help. Now, self-help is using technology to try to automatically enforce rights or duties that are specified in a contract outside of the normal legal process. And that takes a couple of different forms, but two simple examples that you might be familiar with. The first would be a vending machine, where if you put money into a vending machine and make a selection, your food is supposed to come out automatically. And the machine is basically implementing that contract for you automatically, as a technical mechanism. So the fact that you put in money and you now own some of the food that was sitting in the machine, that's sort of the abstract contract, but the enforcement of it happens by technology in this case. Another example that shows self-help in a negative way, the device in the picture on the right of the screen is what's called a starter interrupter or an ignition interrupter. And some cars that are sold with a loan come with one of these devices, and they have the capacity to, they have the ability to render the car inoperable, to prevent the car from starting if you fall behind on your payments. So this is a device that lets the car owner who's loaned it out to somebody be able to prevent that person from using it if they don't pay the agreed upon money in the contract. And notice, again, the fact that you're paying money in exchange for using the car, that's the abstract notion of a contract. And that car owner would have the ability to go through the legal process and force you to give the car back. But putting this technology in place in advance makes that process simpler and more efficient, saves costs of going through the legal process and also time. So there's a view that smart contracts are really just a fancy new form of self-help where they represent an abstract contract, but they have the ability to do some technical enforcement that saves you time and money from going through the legal process. And there's a third way to think about smart contracts in a traditional legal framework, which is to just think of them as a type of arbitration. So arbitration is a method of handling disputes about a contract where you trust a person or a group of people who act as a third party to hear the dispute between the parties of the contract and render a binding decision. So all of the parties agree to do whatever the named arbitrator says. And this is actually used quite a lot, both on TV shows where they have arbitrators who are able to act as judges. They're not really judges, they're arbitrators. But it's also handled in the business world quite a bit, and the main advantage is that arbitrators can act much more quickly and often at lower cost than a full legal process. So you can think of smart contracts as arbitration in the sense that two parties still reach an agreement, but they specify the code of the contract and the system itself as a means of arbitrating any dispute. So they say that we agree to a contract for some sort of interaction, and if there's any dispute, our arbitration mechanism is running the code in EVM and seeing what the result is. So all of those views of smart contracts might be correct to some extent. We don't really know, because there isn't any case law at this point, what smart contracts really are from a legal perspective. But perhaps the most interesting question that people often ask is, can a judge or can the court system nullify your smart contract, or can it change your smart contract after the fact? So this is one of the key selling points of smart contracts, is that both parties agree to some code, and then that code is binding, and there's no possibility of changing it after the fact. However, basically any lawyer will tell you that yes, a judge can nullify your smart contract or can amend it after the fact if any one of a number of conditions is found. So first of all, one of the easiest cases, smart contracts can't be signed under duress, and they can't be signed under undue influences, which is where one party has so much power over the other, for example, is say their boss, and is able to compel them to sign that both parties didn't agree of their own free will, and there wasn't freely given assent to this contract. So it's not clear under which circumstances this would come up, uniquely in the smart contract case, but this is a standard tenet that you can't force somebody to agree to your contract. You also can't agree to a contract unless every party involved has the capacity to agree, which traditionally means that you can't agree to a contract if you're an infant, or if you're drunk, or if you're in a coma, severely incapacitated, those sort of limitations. The one case where this might show up in a blockchain setting, if your key is stolen, and your key signed something, you didn't have the capacity to agree because somebody else had control of your key, so the contract would not be legally binding at that point to hold. So first of all, contracts can't cover legal activity, so it's not possible to specify a contract that says if Alice doesn't pay, Bob can murder her. You also can't specify enforceable contracts anyway for selling drugs or other illegal items. And in the same way, just because you have a smart contract doesn't mean that it gives you license to do illegal activity. For example, in the US, the SEC has determined that some token sales that have occurred using smart contracts constitute an illegal securities offering. So that doesn't, just because a smart contract was agreed to, it's not binding in the face of a decision that the activity covered is illegal or unlawful. There are a couple ways in which judges can overrule the results of arbitration. Now, normally, arbitration is a binding means of resolving any dispute in a contract, but there are a couple of scenarios in which judges can actually overrule the results of arbitration. One of which is conflicts of interest. So if one party bribes the arbitrator, or if otherwise the arbitrator had a conflict of interest in the outcome, a judge can overrule their decision for that reason. They can also decide that the arbitrator made what's called an arbitrary and capricious decision, which means in the judge's opinion they didn't have legitimate reasoning to make their decision. And that might seem somewhat broad, and it is. It basically gives, says if the judge thinks the arbitrator got the decision grossly wrong, they have the power to overturn that decision. Generally in the US, judges have been fairly deferential to the results of arbitration and relatively rarely overturn the results of arbitration, but that is possible. So the question is, what would this mean in a blockchain case if you think of a smart contract system as being an arbitration system? Well, it would mean that if some sort of attack happened at the consensus level, where one party bribed the miners to fork and change the results of a contract, that a judge could probably declare that a conflict of interest and overrule the results of the smart contract on the blockchain. Similarly, with arbitrary and capricious, I suppose that means that if a judge ruled that a fork didn't have a legitimate reason for it, they could also step in and provide some remedy to one of the parties that was damaged by this. And the most interesting case, finally, under which a judge can overturn or nullify a contract is in the case of misrepresentation or mistakes. So in the blockchain case, that would mean that there's a bug in the contract. So perhaps one party was malicious and inserted a bug that meant they didn't have to pay, or they had to pay more than they were expecting to. That would be fraudulent misrepresentation. There could also be negligent misrepresentation, which is just a bug that occurs because the party or parties weren't being careful enough. And it could be innocent. It could be a mistake that's really nobody's fault, but is in the contract anyway. Now, as I said, judges have the ability to nullify a contract or to amend a contract in the result of misrepresentation like that. So what does that mean in a blockchain case? Well, if you have a serious bug in your contract, that means it doesn't behave as both parties thought it did when they had offer and acceptance in a meeting of the minds. It means that a judge can step in and act to remedy that situation. So the philosophy of smart contracts that's often pitched, that the code is law and whatever the code says goes and all bugs are features, this is fairly unlikely, in my opinion at least, to hold up in a court of law. Certainly in the case of fraudulent bugs that are inserted into a contract, I think it's quite likely that a judge would be willing to step in and provide a remedy to the aggrieved party in that case. But the general disclaimer for this whole discussion, there isn't very much case law. There haven't been, to my knowledge anyway, any cases that have been decided that set precedent regarding these things. So it'll be a really exciting area to watch. You can be pretty sure that some of these issues will be argued before judges, and we'll have precedents, and then we'll know a lot more about the legal implications of smart contracts.